Hello, everybody. Thank you for being here. So we started in reality yesterday with a beautiful keynote speech by Albrecht, but some of you joined today. So welcome to this international conference of the ERC project, Migrating Commercial Law and Language, Rethinking Lex Mercatoria. It should have been the final conference, but I asked for 6 months more, so it's not really final, but it's better. I'm really happy about that because I think it's a good moment to think about what we have done so far, and we are still on time to maybe change something on the basis of the discussions we will conducted during these 2 days. I will say something more in introductory remarks. I just wanted to remind you that you should sign these sheets to testify your presence during this conference. It's very important for the ERC. So Matteo Moro, as you already know, is collecting the signatures. So please remember these. Also, who didn't sign yesterday, they can do it today. And also, there are some gadgets for all of you. So these sacks with the booklet inside and something more. They are on the first chair when you enter the room. So please, they are there for you. And also the badge, I hope everyone has it. But anyway, they are over there. Now I am the first one who is going to speak, and Albrecht was so nice to propose to be the chair. I don't know if you want to say something also, or we just go on. No?
I'll just say that I have spoken enough yesterday, and you heard it. And so I volunteered to chair this morning to avoid that Stefania has to preside her own lecture. And that's the only reason why I'm sitting here. I will be very brief. I do really no introduction because we are among friends and we know one another. Of course, Stefania Gialdroni goes way back with her book on East India Company, Una Storia Juridica. And when she prepared that thesis, she was in the international Marie Curie program, when she, among other stations, also spent a year in Frankfurt. That's when we first met. Later, we came together because of this subject in the project headed by Heikki Pialamäki, and also financed with money from the Finnish Academy, where she thrived, and then in the end developed this very, very nice program MICOLL, which we are celebrating today and bringing almost to an end. Very happy that is not yet the real final point. And the discussion about the conference is very fitting for this moment and for this situation, because we have to discuss how should we continue once MICOLL has achieved its goals. So with this in mind, I pass the floor to our host, Stefania.
Okay. Thank you very much, Albrecht. So I think we can just start. Okay, in the program, we try to leave some time for a discussion after at the end of each session. As you already know, the idea is to allow the speakers to use their own language on the basis of this idea of multilingualism. I will also say something about this later. But anyway, the discussion maybe will be in English, just to, or mostly in English, just to keep it simple. Okay, so, ladies and gentlemen, dear colleagues, first of all, thank you for accepting our invitation to participate in this conference devoted to two major historiographical themes at the intersection of legal and economic history that continue to generate lively debate: Lex Mercatoria and Commercial Revolution. Before beginning my introductory remarks, allow me to express a few words of gratitude. We are approaching the final stage of my ERC project, usually known as MICOLL, that began in October 2021, and I owe a great deal to many people. The conference is structured around the three major thematic areas: law, language, and art, reflecting the interdisciplinary nature that has characterized MICOLL from the very beginning. One of the ambitions of this project has been precisely to bring law and language into dialogue when studying the history of commerce. Another distinctive feature of these days is multilingualism. This is, first of all, a tribute to our beloved merchants themselves, who regarded the knowledge of languages as an essential skill. It is also a tribute to one of the founding principles of the European Union, which funded this project. But it reflects, above all, a conviction that has shaped my own academic education, that for a legal historian, familiarity with the major European languages remains indispensable. For this reason, I am particularly pleased that this conference brings together scholars from different disciplines, different countries, and different linguistic traditions. I would also like to thank all the members of the advisory committee, the external experts, the senior staff, the speakers, the chairs, the past and present members of the MICOLL and Justitiam teams. A special word of thanks goes to Francesca Fusco and Matteo Moro, without whom this conference would simply not have been possible. And now the time has come to turn to the subject of the conference itself. Let us begin then with the image that appears on its poster. What we can admire here is one of the most famous portraits of a merchant in early modern Europe, Hans Holbein the Younger's The Merchant Georg Gietze, painted in 1532 and now preserved at the Gemäldegalerie in Berlin. At first glance, the painting appears to celebrate the wealth and social status of a young man of the Renaissance. A little further inquiry reveals that the young man portrayed here is Georg Gietze, a merchant from Danzig who conducted business in London as part of the Hanseatic commercial network. Yet what makes this portrait extraordinary for us is not the merchant himself, it is the world that surrounds him. Gietze sits in his office amidst letters, seals, scales, coins, account books, writing instruments, and objects originating from different parts of Europe, and even a Turkish carpet. He holds in his hand a letter addressed to him by his brother. The address reads, Dem Erzsamen Jürgen Gietze to Lunden in England, meinem Bruder to Handel. Or, roughly translated, to the Honorable Jürgen Gietze in London, England, my brother, to be delivered into his own hands. Other letters are carefully displayed on the wall behind him. So, it is a kind of witness of the connections between London and Danzig, from where the family came from, and we can suppose connections with the who of Europe and maybe the Mediterranean. What is particularly striking is that even Gietze's name appears in different spellings across the letters. Gietze, Giese, Giese. In a sense, the very identity of the merchant is shown as something that moves across linguistic boundaries. Holbein did not merely paint a merchant, he painted a network. Yet networks do not only facilitate exchange, They also generated tensions, disagreements, and conflicts. Behind every letter may lie a disputed payment, an unpaid debt, a failed partnership, a shipwreck, an insurance claim, or a contested transaction. This brings me to a point raised by Albrecht during the preparation of this conference: the absence in the program of a paper specifically devoted to mercantile procedural law. At first sight, the observation was entirely justified. Yet, as I began reading the abstracts of the papers that will be presented over these 2 days, I realized that procedural law is everywhere. And, for example, yesterday, 90% of the Lex Mercatoria in the Little Red Book of Bristol is about procedural. I would therefore like to provide a brief overview of mercantile justice, also for the benefit of colleagues from other disciplines. When historians examine medieval and early modern commercial justice, they are confronted with a highly fragmented landscape. We encounter arbitration, yield courts, urban tribunals, maritime consulates, and fair courts. We could even say that the specificity of commercial law manifested itself to a great extent in the demand for a special form of justice: faster, less expensive, more closely adapted to commercial practice, and less constrained by the formalities of Romano-canonical procedure, the so-called ordinary procedure. Despite the fragmentation, we can identify 2 main forms of conflict resolution in the mercantile world: arbitration and special mercantile jurisdiction. Arbitration constituted one of the earliest and most fundamental forms of commercial justice. In Roman law, arbitration was essentially contractual in nature. The compromissum allowed parties to entrust the resolution of a dispute to a third party without producing a true res judicata. During the Middle Ages, however, partly under the influence of the Church, arbitration acquired increasing importance. In the commercial sphere, arbitration responded to the very practical concerns of merchants, avoiding the costs, delays, and uncertainties of ordinary justice. There are also, several quotations about this, and maybe I can say something later. In a world characterized by political fragmentation, overlapping jurisdictions, and conflicts of competence, arbitration allowed merchants to choose expert judges, often members of the same professional milieu, and obtain quicker decisions. Alongside arbitration, specifically mercantile tribunals emerged. The institutional landscape was extraordinarily diverse. For historians, 2 difficulties immediately arise: the lack of uniformity among different cities and regions, and the relative scarcity of surviving documentation, because of the summary procedure we are going to talk about. Jurisdiction could be defined in different ways. The Genoese jurist Bartolomeo Bosco, writing at the turn of the 15th century, summarized the jurisdiction of Genoa's mercancia through 3 elements: persons, goods, and transactions. The person had to be a merchant, the goods had to be merchandise, and the transactions had to be commercial dealings. Yet in practice, this apparently simple formula generated a remarkable variety of solutions. The composition of the courts also varied considerably. In some cases, disputes were decided by merchants elected by their peers. In others, by judges appointed by civic authorities. Some tribunals included learned jurists, while in others, their participation was limited or even excluded. Despite this diversity, one element appears with consistency across Europe: the use of summary procedure. Summary procedure did not originate in commercial courts, but in canon law. Between 1312 and 1314, Pope Clement V's constitutions, Dispendiosam and Sebe, together with Emperor Henry VII's constitution, Ad Reprimandum, established a simplified procedural model designed to overcome the delays and costs of ordinary litigation. The most famous formulation stated that proceedings could take place simpliciter de plano ac sine strepitu iudici et figura, simply, plainly, and without the noise and formalities of ordinary judicial procedure. The Constitution Sepe, later glossed by Giovanni d'Andrea, one of the most influential canon lawyers of the Middle Ages, explained concretely what this meant. Judges to dispense with the formal written complaint and the litis contestatio, reduce delays, reject dilatory exceptions and appeals, limit the number of witnesses, shorten deadlines for the production of evidence, question the parties directly when equity required it, omit certain procedural stages, and pronounce judgment without further formalities. Baldus de Ubaldis, the leading commentator of the late 14th century, expressed this idea clearly. In merchants' courts, one should judge according to what is just and equitable, omitting unnecessary legal formalities. A few Italian examples could help us understand how different mercantile jurisdictions work. The Collegio del Cambio in Perugia, the Mercancia in Bologna, and the Mercantile Magistracy in Bolzano. Just a few images that show you how rich was the decoration of the audience hall of the Guild of Money Changers in Perugia. The Guild Statute of 1377 informs us about the principal features of the jurisdiction exercised by the Collegio del Cambio of Perugia, the Guild of Money Changers. 2 auditores elected by the General Assembly of the Guild were entrusted with hearing the parties and deciding disputes. Their jurisdiction was limited to cases in which one of the parties was a member of the corporation. A little more than a century later, however, in 1482, Pope Sixtus IV extended this jurisdiction to all matters relating broadly to monetary affairs, thereby bringing even non-members within its scope and formally recognizing a development that had already occurred in practice. The auditores were required to administer justice at least 3 days a week, on Mondays, Wednesdays, and Fridays, both in the morning and in the afternoon. Having heard the arguments of the parties, they were expected to examine and discuss the cases briefly and simply, and to render a decision within 2 months. The proceedings, not surprisingly, were to be conducted summarie simpliciter et de plano sine strepitu et figura judici. The Mercancia of Bologna provides another interesting example. This was a kind of super guild, or, to borrow Mario Ascheri's definition, an inter and supra corporate institution, un ente inter e sovra corporativo. Unlike other cities, such as Pavia or Cremona, access to its special jurisdiction did not require enrollment in a guild register. It was sufficient to carry on the activity of merchant or artisan within the city of Bologna. According to the Statute of 1436, the court's jurisdiction was limited ratione materie to matters concerning the jus mercatorium, which is very broad, of course. The judicial body consisted of 12 consuls representing the city guilds and was presided over by a foreign jurist trained in civil law at one of the major Italian universities, Bologna, Perugia, Padova, or Pavia. Here, therefore, unlike in some purely mercantile tribunals, professional legal expertise was formally integrated into the structure of commercial justice. Yet despite the presence of a learned judge, the procedure remained explicitly summary. The statute required that disputes be decided summari de plano sine strepitu et figura iudici. These examples suggest an important conclusion. Jurisdiction and institutional structure varied considerably, but the objective remained constant, avoiding the delays of Romano canonical procedure. Of course, this ideal of speed should not be romanticized. The sources show, especially for Bologna, I would say, that commercial justice could suffer from many of the same problems of ordinary justice. Postponements, absentee parties, procedural delays, intervention of jurists and lawsuits lasting for years. This was demonstrated precisely for the case of Bologna by Alessia Legnani and Michilli. Nevertheless, procedural celerity remained a powerful normative ideal and at least to some extent a practical reality. The mercantile magistracy of Bolzano offers an equally revealing example. Established in 1635, this was the court of the Bolzano fairs, which brought together merchants from northern Italy and southern Germany, especially. Each year, the merchants who regularly attended the fairs were required to elect one councillor and two consuls, all merchants, who exercised first instance jurisdiction over all disputes arising among merchants of whatever nation in connection with commercial transactions conducted during the fairs. A second instance tribunal was also provided for, likewise composed of one judge and two councillors, whose decisions were final and not subject to further appeal. Particularly interesting was the balance between the two merchant communities that met at Bolzano. If the presiding consul in the court of first instance was Italian, the councillors had to be German, Alemanni. In the appellate court, the composition was reversed. The tribunal thus sought to guarantee both expertise and a degree of equilibrium between the two principal commercial groups participating in the fairs. The statute further prescribed that judgments were to be rendered summariamente, con lo stil mercantile, udite le ragioni delle parti, riguardata la sola verità del fatto, senza formazione di processo solenne figura o strepito di giudizio. And this is dated 1635. Appeals had to be lodged within a single day. Although the authority of the magistrates formally ended with the fair itself, their judgments remained enforceable afterwards, and the other courts of the county were required to ensure their execution. Even from these few examples, commercial justice appears fragmented, local and diverse. Yet legal doctrine, grounded in the Corpus Juris Civilis, played a crucial role in systematizing commercial practices and customs, but only and very slowly from the 16th century onwards. Benvenuto Stracca devoted an entire section of his Tractatus de Mercaturas et Mercatore, published in 1553, to mercantile procedure. Over time, with the rise of central tribunals, commercial justice was progressively absorbed into more institutionalized judicial structures. The Rota of Genoa, established in 1530, contributed both to the decline of older mercantile courts and to the systematization of commercial law through its Decisiones de Mercatura, first printed in 1582, that subsequently circulated throughout Europe. The 16th century, the century of Stracca and of the Genoese Decisiones, thus appears as a moment of transition, when commercial law and mercantile procedure very slowly began their path towards modernity. What emerges from these examples Sorry, a little bit late, but okay, I'm starting not in the best way, but okay, allow me 5 minutes more. What emerges from these examples is a sort of paradox. On the one hand, commercial justice appears deeply fragmented. And yet, despite the institutional diversity, we repeatedly encounter the same procedural ideas: speed, informality, flexibility, etc. It is precisely this tension between fragmentation and commonality that brings me to the two major historiographical themes of our conference. I fully agree with Albrecht's reflections, especially when he stresses that we have probably paid little attention to the relationship between legal renaissance and commercial revolution. This is the point that the question I asked yesterday, and it's very controversial, as you explained, because of many reasons. But I just want to stress that this tension, in a way, or this gap is particularly important for MICOLL because in some respects our historical lexicon of commercial law is an attempt to reconnect these two words, the legal renaissance, the Roman law tradition, and this commercial revolution, and these new ideas that came from, the mercantile world. So why we try to connect those two words? Because we draw our attention simultaneously on documents generated by commercial practice, such as contracts and letters, and on the learned legal literature. The lexicon focuses on legal institutions that were either unknown to Roman law, such as insurance and the Bill of Exchange, or transformed so profoundly during the late Middle Ages that they marked a point of no return in European legal history, such as partnership and bankruptcy, or rather the legal management of insolvency. At the very same time, however, the commercial world experienced another transformation, one that we might legitimately call a revolution in dispute resolution. So merchant courts and merchant procedures developed alongside the Romano-canonical process, often defining themselves in explicit contrast to it. We saw local practices, local laws, and local jurisdiction. And yet, something was shared. The evidence lies perhaps precisely in the words of commercial law themselves. For centuries, commercial terminology traveled across Europe from south to north, especially, migrating through loans, translations, and cults. Words moved together with merchants, contracts, accounting technique, and legal practices. The result was not uniformity. Similar words did not necessarily correspond to identical concepts, just as similar concepts were often expressed through different words. What emerged was not a single legal language, but a family of related languages connected by continuous processes of adaptation and exchange. And perhaps it is here that we return to the notion of a mercantile culture evoked by Carlos Petit, a shared cultural space shaped by multiple forms of normativity, among which law was certainly important but not exclusive. From this perspective, the Lex Mercatoria doesn't appear as a coherent and universal legal system, but rather as a complex web of practices, concepts, and normative expectations circulating across Europe through the movements of merchants themselves. And now I'm really going to finish, and I want to finish with an image again. This time, the Lion of St. Mark, standing atop its column in the Piazzetta San Marco. Its history is, in many respects, still a mystery. We do not know exactly when or how it arrived in Venice. Venetian sources are surprisingly silent on its transportation. By the end of the 13th century, however, the lion was already standing on its column and remarkably was already in need of restoration. For centuries, scholars scholars have debated its origins. One recent hypothesis, supported by research carried out at the University of Padua, suggests that the sculpture may originally have been a Chinese Zenmushu, a monumental guardian creature cast from bronze produced in the lower Yangtze region and transported to Venice during the Middle Ages. Some have even speculated that it may have reached Venice in separate pieces, perhaps through the journeys of Niccolò and Matteo following. Whatever or not this is true, it isn't the point here. What matters is that the lion we admire today is not an untouched object that has survived the centuries unchanged. It has traveled, it has been displaced, it has been repaired, restored, transformed, and repeatedly reassembled. Its origins remain uncertain, and yet its symbolic power has never diminished. Perhaps this is why it offers such a fitting metaphor for our themes. From a historiographical perspective, both the Commercial Revolution and the Lex Mercatoria increasingly appear less as coherent and self-contained realities than as complex historical constructions, whose fractures, layers, and transformations become visible upon closer inspection. But we can adapt the metaphor also to the Lex Mercatoria itself. So we have a mercantile world which is very heterogeneous. We have legal traditions, commercial practices, procedural techniques, linguistic borrowings. But we have, so we don't have a uniform system, but we have something in between, a dynamic process of the adaptation, translation, negotiation, and recomposition. So, to go back to the title, I'm very sorry that I'm so late. We asked if the gods have fallen. Perhaps, like the lion itself, they have simply revealed themselves to be more complex, more fragmented, and ultimately more interesting than we once believed. Thank you for your attention.
Thank you very much, Stefania. You finished with this wonderful metaphor fitting to our place of venue, and so the Venetian lion, Venice being the city where the lions fly and the pigeons walk by feet. That's splendid and surely a nice start for our discussion. Before I start with that, I've got a question. We are not on the Skype schedule, are we?
No, we're not. We have this 30 minutes of debate, so we have time for debate. So if the papers are a little bit longer, it should fit anyway.
So no excuses needed for taking 5 minutes more and for taking part in the discussion. Anja Amen.
Really, question, but a remark. So yesterday and today, the two lectures we listened already, I realized like totally agree that we should have a greater focus on the procedural law, on the procedure of the jurisdiction, commercial, trade, and so on. So my remark belongs to your saying that the merchants have the possibility to choose the judge. Maybe I misunderstood that. And that affects the topic Anna was organizing in Münster 2 months ago, a workshop. And so there I think we worked out, but the main elements of this special jurisdiction we are talking about now seem very singular. Like you described, we can find it in Bolzano, very similar in the old empire and in other places in Europe. So I'm wondering if this is not a very important point regarding the topic of our conference here, the Lex Mercatoria. It is very similar. It can be observed in many places. So, but the very interesting question is now how these jurisdictions can be distinguished. On the one hand side, in my observations, you have privileged jurisdictions, privileged by a sovereign, like in Holstein.
Yeah.
And on the other hand, you have a special commercial jurisdiction established by custom for us, like in Nuremberg. And I think this is a very interesting question. We could go further on.
Okay, first the questions, yeah, okay, yeah. I don't know, first the questions.
As you like.
Can I answer? Okay, first,
sure.
okay. So, I think that really we should focus more, maybe with the big project on comparison between procedures, because there are documents, of course, even though it was not formally in the sense of the ordinary process, but there are things that we can study. And it's really a strange equilibrium between the similarities of summary procedure based on this normative, the source, so the canon law source, because you have the description of what is summary procedure, okay, and it is a source that is there for the full Christianity in a way, so there is this universality given by canon law, so you have the basis of summary procedure there. And then you have these different compositions of the courts. I said that you can they could choose the judge, especially referring to arbitration, okay? But usually then merchants chose among themselves. So this is true also, okay? Members of their community. But what you said last is really very interesting. So this, the role of the state, let's say, or if they had a special jurisdiction because a sovereign gave a privilege, like in the case of votes, or they took. And here lies a central question of the autonomy of merchants and mercantile law, how far it goes. And it was also one of the questions that yesterday Albrecht asked the relationship with sovereignty in a way, and how really autonomous were those merchants, okay? So this could be another myth, okay, which is the myth of Lex Mercatoria at the end. So, thank you very much. Maybe this could be a new path of research, a kind of project comparing different mercantile procedures. I think it doesn't exist at all, no? Okay, thank you. Yeah.
Emanuele Conte.
Thank you very, very much, because it was also really very, very fine. I think it was also the opening lecture of all the Albrecht's guests. So I wanted to stress one technical point, and it was to test my interpretation, because I may be wrong. Mm-hmm. So you say that the ethical for commercial procedure, which is absent in our seminar but is present everywhere, is arbitrary. Arbitration.
Yeah.
Right? So, and you define arbitration as this procedure in which you have not to state the case in front of the court, because you discuss directly about what happened and not about the legal statement of what happened. This is exactly what Roman law says about the statement of the law, the causa coniexio, which is called causa coniexio in the Dyble sheets. Okay. Causa coniexio means that the lawyer goes to court and says what happened is a case of obligation, or a case of liability, or a case. So it states the legal field in which the discussion with stuff. And this starts with the scribus, because the counterpart will argue against this. In my view, the whole 15th century has been devoted by lawyers to teach the practitioners how to present cases in court, how to write a libellus. So libellus is really a great form. And starting from the 14th century, in different fields, and particularly in criminal law, lawkeepers who decide that this is too complicated. Sometimes they need something very simple. Then we have seven and misteriosa and the quick procedure without this passage of stated order. So you decide directly on the reality and not on the fictional description made by lawyers, right? So, am I right? Commercial law goes to the same extreme and tries to present a way to decide controversies without passing from this very legal description that sets the field in which the trial will happen. So this,
Okay.
I would test this in the light.
Okay, thank you very much. What I can say is that I think that maybe so far we didn't pay enough attention to this parallel between, this kind of revolution in commercial procedure that goes parallel to this revolution of the ordinary process, because it's really something that also characterizes the so-called legal Renaissance. Okay, we studied, with the difference, Bologna is more glosses, the other schools focus more on practice, but we have all those works, the Arboris Actionum, etc., the Ordines Judiciari, focused on this. This was a central problem, because of course law is about that. Law is to solve a conflict. This is a central issue. But, and merchants have the same problem. And what I always want to make these links with this environment of the legal Renaissance, because it was there. I mean, they had similar problems. And at the end, the solution was also inspired by what happened in a canon law procedure. And so we cannot separate completely, at least in Italy, okay? But I think it's a European phenomenon, okay? So also in this sense, the question that I asked yesterday, maybe we should put in contact much more these, the Rinascimento giuridico in general with the world of commerce in a way. So it's not so separate. For example, in these cases, okay, the inspiration for summary procedures. So central issue for law in general, including commercial law, which is a part of law, and it's not, only a mercantile something done in practice. So thank you very much for again on procedure, because I think it's very important. Yeah.
Joshua, you.
Thank you very much, Stefania, for your very beautiful presentation. I went with beautiful images as well. I have actually two questions. One on the images, but one first on the law aspect. What I learned a lot about what you are presenting here on the Italian cities. I read a little bit about the Netherlands, with the whole country's situation. And something I've seen there first in Bruges in the 13th, 14th century, and then late 15th, 16th century in Antwerp. I may say that by the merchants, I think I have the impression jurists are esteemed in the sense that they are consultant, they give advice to the merchants. Within the guilds, for instance, they're often present, but without voting. rights, so they cannot help to decide. Also,
Okay.
they are sometimes appointed, the jurist is appointed as the secretary of an arbitration commission, for instance. But again, not with voting rights. So actually, they are esteemed as some kind of artisans, that people know the law and we have to listen to them. But
Okay.
we do not trust them enough to give them also the capacity, the competence to help and decide, which is something in our commercial courts will only happen in the 20th century. In 1910, we made president of the court still with two lay judges with merchants. The president becomes a lawyer, a professional jurist, and today it's still like that. But everybody says we have the jurist as a president, and then the two other merchants, whatever, are actually just flower pots, and they don't do anything. So it completely turned around, and I wonder. In 15th century, for instance, in Bruges, we see jurists appear, and they actually went to Bologna and other cities in the south to take their degree, and then they are very esteemed when they come here in our region, but we don't give them any confidence. As there must have been many more jurists in the region over there, did they ever have operatives to help and decide? Were they just counselors, or were they also both to give the companies to decide? That's my first question, and I have one on my account.
Okay, so first this one, because okay, thank you very much. It is not easy. That's why we should do a kind of project to compare. The case of Bologna is a kind of exception where they, in the mercancia, so this super guild, the merchant guild of the city, the court was presided by a learned jurist, but it's a kind of exception. But it is Bologna, and maybe it's not a chance, you know. Okay, so in general, they were okay. For example, also in the there are cases, I'm thinking also about France and Lyon, where there were notaries that were certainly learned in the fair court, that were certainly learned jurists. Maybe Anna wants to say something. Before Italy, I know for sure only the case of Bologna. In general, they were merchants, but about the fact that they were respected, but merchants were skeptical, I can quote Benvenuto Strapka, who wrote the treaty in 1553, the Mercatoria, a part on procedural law, and at the end he said, please trust jurists, they are good. When there are difficult cases, you have to ask a learned lawyer, okay? But it says that in general, merchants didn't want to do that much, that they were a little bit skeptical, okay? And yeah, more or less is this. Sometimes they were included, and of course there were consilia given by learned jurists, like commentators. For example, Baldus de Ubaldis famously did this also on mercantile issues. Not a lot, but I would like to go in depth in these. This way, of course, there was different, but for judges really in mercantile courts, for sure I know only the case of Bologna. Okay, and the question about the iconography?
Yeah, about the iconography, beautiful images, so and I had that seen, and almost all of the, especially the paintings you showed, are 17th century Baroque allegories.
No, they're different. This is end of the 17th century.
Yeah.
Which is, yeah.
My question is actually most of those institutions are much older, and so this is probably a second or the third generation of decoration. Probably, I think, because allegories are not very medieval, or rather early modern.
Yeah.
At least in my region, so I don't know for Italy, you're always ahead of us.
No, that's true. For Flanders, it's not true. It's the other way around.
At least there's an interaction. But is there a preceding generation of other images, or is Is this, as far as you know, the traditional image already system?
Okay, so if the iconography remains the same, no, sorry, or there are changes in the iconography.
Yeah, so what we now see are allegories, personifications
Yeah.
of Germania and
Yeah.
therefore it's Justitia, budget.
Yeah.
But was there something before that?
Yeah, okay. I mean, this is a very peculiar painting with, you know, these two nations together. But in general, Valeria Panuzzo will talk about this tomorrow, about the virtues. This is a very peculiar, anyway, of the magistrate of Bolzano. But this is more, okay, we have a few things, I would say, in the Middle Ages for merchants that have survived. If we start really with things that are more interesting in the 14th, 15th century, 16th century, and this is this Collegio del Cambio that was decorated by Perugino, so the Lo meglio maestro d'Italia at the time, from Frankfurt. But what is very typical are virtues, you know, for virtues. And also, in some cases, the important man of the castle, and in this case, I mean, I think that the most spread iconography is that of virtues in general, not the four virtues. It's not. And then Mercury sometimes for you know, the speed of commerce, etc. I don't think that there is a great difference. I think it remains quite homogeneous during a long period of time. But we will see this maybe better tomorrow. Okay. Okay. Thank you very much.
I think we are picking up
Yeah, sorry.
a huge delay even by Italian standards.
Yeah.
So I suppose we have to
yeah.
continue to the next lecture, and I'm happy to introduce Jake Dyble, author of the recently appeared book on managing maritime risk that was on general average, and it has made quite an impact. Jake was a member of Stefania's team, and because she was so successful in choosing good people, they all were
They all went
also in demand
somewhere
elsewhere.
else. Yeah, exactly.
So, and some of them moved on, which led to a bit of fluctuation. But that's not really our subject. The subject is that indeed Jake was able to procure his own project now, and he's pursuing that at the University of Padova. But academically, his home is England, Exeter, and his academic supervisor, Maria Fusaro, is here as well. Okay, thank you very much, and the floor is yours.
Thank you. My own contribution today will begin with a piece of original research undertaken as part of the MICOLL project, which was an intellectual history of the Lex Mercatoria thesis. Some of you will remember a preliminary version of this given at an earlier MICOLL workshop, and it was published last year in Law and History Review. So my first aim in sharing this with you is to anchor our discussion at the stratospheric level of abstraction at which Lex Mercatoria conversations usually take place. It's easy for debates to take on an ungrounded, even hallucinatory quality. And as usual, only a proper grasp of the terms of the debate can stop us from drifting off into the abyss. And in fact, a lot of the misunderstandings that have characterized this vast and sprawling topic can be traced to a failure to deploy individual words precisely. But my aim is also to use this research as a springboard for further reflections about a research agenda in a cards on the table, hopefully post-Lex Mercatoria world. And I hope in this respect to develop a few ideas that Albrecht raised in his keynote yesterday. So I first encountered the Lex Mercatoria debate in the first few months of being a PhD student And even then, for me, it was a slightly bemusing topic, since nobody I read seemed to seriously believe that anything resembling the Lex Mercatoria actually existed. And until I started on the MICOLL project, I'd only ever encountered the medieval Lex Mercatoria as a kind of recurring boogeyman of commercial law historiography, a shibboleth which was constantly set up simply to be knocked down. And even the eternal recurrence of this debate seemed to have become something of a scholarly trope. So I felt it was important, or Stefania and I felt it was important, to understand this idea better on its own terms, even if only from a know your enemy point of view. If we were to spend the next 4 years rethinking this idea, it seemed important to understand why people had spent so long thinking it in the first place. The aim, to paraphrase the famous historian of political thought Istvan Hont, was to use intellectual history to unmask impassives and eliminate repetitive patterns of controversy. My main question setting out, therefore, was what accounts for the apparently incredible staying power of this idea? And it was for this reason that I decided to concentrate on the period 1890 to 1970, because it was repeatedly claimed by critics that the idea could be traced back to Levin Goldschmidt in the late 19th century. At the same time, it was claimed that the Lex Mercatoria, the medieval Lex Mercatoria thesis, was nothing more than a foundation myth for the new Lex Mercatoria movement. The idea that the norms of international business should be the usage of the international business community as interpreted by arbitration tribunals. And yet this myth didn't take off until the 1960s. So what was happening before? How can we have a foundation myth which begins 70 years before the thing it's supposedly supporting? So I think the Lex Mercatoria is probably best reduced to 3 principal claims. The Mercatorists claim that at some point in the medieval past there existed a merchant law which was universal, or perhaps international, transnational, cosmopolitan, uniform, that was autonomous, or perhaps independent, distinct, or a body of law, and was also customary, or unwritten, or based on usage, or based on practice. And I think archival historians who criticize the Lex Mercatoria have tended to focus on universal, which admittedly is probably the most important claim for the new Lex Mercatoria, but also conveniently for us, the most difficult and the easiest part of the thesis to disprove. And what I want to talk about today, and it seems to be a bit of a theme, is to talk about the autonomy claim instead. So as I said, most critics of the Lex Mercatoria trace the idea back to Levin Goldschmidt in the late 19th century, specifically the Universalgeschichte of 1891, which was originally intended as a historical introduction to Goldschmidt's guide to the German commercial code, his Handbuch des Handelsrechts. And a survey of Mercatorist literature certainly confirms Goldschmidt's importance in the propagation of Mercatorist ideas, but a careful reading of the text reveals that he was no Mercatorist himself. I say a careful reading because the Universalgeschichte, which was an unfinished work, seems to veer somewhat wildly between almost contradictory statements. Anyone looking to find support for the Lex Mercatoria will certainly find things to quote, but the point is that one finds them almost immediately contradicted. So, for example, talking of the jus mercatorum of the Middle Ages, Goldschmidt writes, commercial usage, local or territorial in origin, gradually becomes in large part universal, and this is often quoted. What is not quoted is his next sentence, but the opposite also takes place, that universal commercial usage is quite often fixed locally and thus differently, thanks to statutes, single laws, and codifications. Some more examples. To universal imperial law, Roman, and universal canonical law can be added a modern law of commerce, no less, one might say, universal. And perhaps the most quoted Goldschmidt line, the greatness of the medieval commercial class and its importance as a model for all time consists in it having created its own law derived from its own needs and concepts. And yet, this is seemingly contradicted almost immediately. So, although the merchant class supposedly invented its own law, they were not its sole architects. But we also learn that Roman private law found a ready welcome. Moreover, we are told we should not exaggerate the concept of universality. More important than a statistical demonstration of particular uniformity is the discovery of original, perhaps localized germs of legal ideas fully developed later. What we don't find in Goldschmidt is the story of merchants developing their own law independent of the national state. Instead, we are presented with a merchant law which, generously synthesizing, we might say was partially autonomous from Roman law on the one hand and canon law on the other. And in fact, I think it's fair to say that the existence or not of this law is not Goldschmidt's primary point of interest. What is ultimately underlined is that we have the germs of future legal ideas rather than a system of fully developed laws per se. It's a dynamic process of legal innovation that interests Goldschmidt, signaling the beginning of a teleological process that led to the creation of modern commercial law. For a jurist employing Goldschmidt's historical dogmatic method, i.e. who uses a historical awareness in order to refine and adapt legal institutions in the present, of course the Middle Ages are a historical episode worthy of attention. But there are other reasons why the medieval merchant class, and in Goldschmidt's case he means the medieval class of the Italian cities, should be considered important. As we've read, it was not just an important historical moment in particulars, but a model for all time. And I suggest we should read this remark in relation to the great legal project of the late 19th century, the creation of the German civil code, the BGB, which was still underway in 1891. Goldschmidt, to his great chagrin, had not been invited to work on the BGB, but he had been instrumental in its preliminary steering committee when it was decided to keep commercial law and civil law codes separate. And this was not necessarily intuitive, since many acts of commerce, buying and selling, lending and borrowing, might equally be considered fixtures of general private law. Famously, Italy, of course, would decide to have a single code rather than divide them into two. A lesser legal mind might have argued that it was the static existence of separate laws that mandated a division between commercial and civil codes. Instead, Goldschmidt argued that it was precisely the dynamic tendency of the commercial classes to continually create new rules that justified what would inevitably be a somewhat arbitrary division between the two bodies of law. Moreover, the medieval commercial class, a model for all time, underlined the need to maintain a historical awareness as a prophylactic against the potential rigidities of codification. As Goldschmidt himself puts it in a memorable passage, we can compare commercial law to a glacier. In the lower regions, it melts and unifies with the general mass of rainwater, i.e. civil law, whilst in the upper regions, new ice continues to fall. In reality, as far as the Lex Mercatoria thesis is concerned, I argue that the key word was a little-known essay by a little-known British author, William Mitchell's Early History of the Law Merchant. Even though this work had little impact at the time, it became a key source for a whole strain of Mercatorist thought, notably the one that passes through Harold Berman to Leon Trachtenman and Bruce Benson. And I've placed this file photo here because no one seemed to know anything about William Mitchell. He appears from nowhere, writes a really influential work on the Lex Mercatoria, and disappears.
Yeah, it's true.
Anyway, it turns out that he actually wrote this essay while he was an undergraduate in his late 20s at Cambridge, having first worked as a provincial school teacher and a teacher at a Collège du Commerce in Brussels, interestingly. And what I think Mitchell does is yoke Goldschmidt's point about the medieval merchants as a font of legal innovation to a pre-existing Anglophone idea, the law merchant. Mitchell argued that the Middle Ages saw the successful assertion of new principles of law. These principles, distinct from the common law, were the law merchant. And in the 16th century, he says, all the great principles that mark the commercial law of modern times had evolved and been asserted. Now, of course, some of this is simply factually incorrect. Many of the great principles of the commercial law of modern times had not been asserted. the joint stock company being perhaps the most egregious of those Mitchell does not mention. We also know that principles like the negotiability of bills of exchange was not at all successfully asserted. In fact, in many places, including northern Italy, it was not possible. More important for our purposes, however, is the fact that an open-ended process, which was explicitly teleological, is now reified and made to become something that existed at a single point in time. And in neither Goldschmidt nor Mitchell's case do we ever arrive at the early modern period. In neither work is the importance of the Lex Mercatoria to be found in its autonomy from national state law. And in fact, this was an innovation in the 1960s as part of Clive Schmidhoff's work on the Lex Mercatoria, who was also the first to explicitly connect the Lex Mercatoria to non-European sources. And the reasons for this change quickly become apparent. It's well known that Schmidhoff's first explicit engagement with the Lex Mercatoria was in an article of 1961. And this was in fact laying the groundwork for a conference he had already called in 1962, New Sources of Law in International Trade, where he pitched the idea of a return to Lex Mercatoria. But it turns out, reading the reports of this conference, that virtually nobody was convinced. And I think the arguments of the communist delegates are particularly interesting and suggestive. They argued that the Lex Mercatoria was nothing more than a basis for perpetuating Western patterns in public international law under the guise of cosmopolitanism. And in fact, when we turn to a reconstruction of Schmidhoff's thinking, we have some more, I would say, suggestive rather than conclusive data, because it seems that his thinking significantly changed between 1956, where he writes an article about the importance of comparative law as a way forward, and 1957, where he starts talking about commercial law as a universal law of nature, based on a reading of Lord Mansfield. So we know that Berthold Goldman's first engagement was an article in Le Monde in the wake of the Suez Crisis, and it seems that Schmidhoff's thinking was impacted in the same way. So I think, in a way, a post-colonial angle to the certainly to the new Lex Mercatoria would be an interesting avenue for research, one which unfortunately I had no time to pursue. So, at this point, I will simply leave, I think, an indicative quote by Henry Kissinger, that empires have no interest in operating within an international system. They aspire to be the international system. And I think it's very interesting that Western European lawyers start talking about an international system at the end of empire. Mm-hmm. Let us instead reflect on the second historical claim made by the Lex Mercatoria thesis, the idea that the Lex Mercatoria was autonomous. I think the follow-up question that emerges from this survey is, autonomous from what? Each iteration of the thesis is interested in different aspects of the autonomy, whether that be from Roman law, canon law, English common law, general private law, or the national state. And I think we also have a question of what is meant by law, which gets at the very nature of that autonomy. When do separate laws become a law? A body of law that might be made equivalent to canon law or Roman law or English common law, which all ultimately had roots in a source of political or religious authority. Finally, we might note that many early Mercatorists, as well as some later writers like Berman, are really more interested in the emergence of legal principles than actual rules per se. And I think it's this autonomy claim that makes the Lex Mercatoria so difficult to dispel, because it contains both a grain of truth and resonates with certain rhetorical stances that we find in our sources. So what should we say about this autonomy if we want to adopt a general framework? I think it's important to recognize that commercial law, depending on time and place, has enjoyed a degree of autonomy along a number of related but independent axes. So we may have special courts and special judges, but that in the event don't actually function wildly differently from their civil law equivalents. Or there may be no distinct courts, but separate rules or separate sources of law. There may be procedural autonomy using special rules regarding evidence or appeals, or some combination. But I think it's worth saying, even though summary procedure is perhaps the most universal fixture, I think in many examples we find courts which are ostensibly using summary procedure, but which has come very much to resemble ordinary civil law procedure somehow. Or in fact, there may be no autonomy whatsoever. To give an example, for a long time there was a very widespread myth that Muslim subjects in the early modern Ottoman Empire didn't engage in commerce at all, simply because their social identity, as part of the military class or as a janissary, for example, hid their extensive mercantile activities in plain sight, aided by the fact that Sharia law makes no formal distinction between commercial and civil law. We might also draw an analogy with studies of women's work in the early modern period, which has often been missed precisely because while men's social identity was tied to a specific profession, the social identity of women tended to be tied to their marital status. And so now we have a very productive methodology, which is rather than looking at what women are, how women are described, looking at what women are actually doing in the sources. And I think it should be said that where autonomy does exist, whether based on ratio personarum or ratio actionis, that autonomy will always be contested and dynamic based on local conditions and power balances. In short, autonomy is always a political question, and it's never a done deal which is agreed by all sides. It's continually in flux and renegotiation. And mercantile autonomy was particularly important in medieval Western Europe and early modern Western Europe, where merchants are usually defined by what they are not. They are not shipmasters, they're not retailers, and they're not artisans, thereby subordinating the figures who are most potentially dangerous to their profit margins. Moreover, most of our sources do not deal with this question directly, are not describing a reality, but trying to create it, to justify or resist the imposition of a certain rule, jurisdiction, or procedure, whether that justification be the lex mercatoria, or the merchant style, or a claim that commercial law is a universal law of nature. And this also gives rise to a continually recurring narrative of the reception of commercial law by learned law. Whereas I think it's more accurate to say that trained legal professionals have always acted as mediators between ideals of justice and interests. So to the future. Whether or not it takes the form of a lex mercatoria narrative, whether indeed the narrative is given a specific legal character or not, the idea that medieval merchants developed the original, perhaps localized germs of economic modernity, perhaps even something called capitalism, continues to hold wide sway. This is just one of the reasons why I think it can make sense to consider lex mercatoria and commercial revolution under the same umbrella. In both narratives, it's often the long-distance merchants who supposedly made the difference. Though why this should be so, and whether it even makes sense to differentiate long and short-distance trade is never fully contemplated. Viewed at a sufficient distance and with sufficient determination, the modus operandi of these merchants can be made to appear very similar. So we heard from Albrecht yesterday, should we take the lex mercatoria down from its pedestal? And the answer was 9. I didn't know that when I wrote this presentation. Obviously now I know better, so I'll just say what I was going to say. Anyway, my personal opinion is that arguing against the lex mercatoria means we end up saying what our object of study is not, rather than saying that what it was. And I think in this respect, a willingness to more openly acknowledge the public and political dimensions of mercantile law is a good start, and in fact is underway already. This is not to say that law was merely a cover or a cipher for power relations, but that the political dimension should be acknowledged as constant and normal rather than an aberration. And I think one productive avenue of research already signaled by Guido, for example, is in the absence of a lex mercatoria, how were legal decisions accepted, transposed, or overruled in other jurisdictions? There's little sense, in my mind, in keeping the lex mercatoria goddess, or I would rather say idol, on a pedestal. and certainly no sense in repeatedly setting it up only to cast it down. Of course, any attempt at describing the broad sweep of history is always open to nitpicking and criticism from area specialists. Ultimately, however, even a modified Lex Mercatoria narrative is not only too long, but too unidirectional to make proper sense of the past. The desire to draw a single line from feudal to capitalist, from merchant law to commercial law, from pre to post-revolution, will always be easier to communicate than a world of back and forth, give and take, and the repurposing of old structures. But then again, nobody said that finding meaning after faith would be easy. Thank you very much.
Thank you for this wonderful and precise lecture where you rightfully asked us to take terms and words, especially our key terms, closely under supervision and discuss them. So we do not only need collaboration between jurists and historians, but also with linguists, with experts on language. And that is part of the MICOLL project too. We really don't have time for discussion, as I learned, but still I will allow a few urgent questions. Yes, please, Anna. The microphone is
microphone
here.
Dov'è? No, ce n'è un altro. Ok.
C'è un altro?
Thank you very much for the wonderful presentation. I had one question about Gauchery and Albrecht. The fact that he works with universal commercial law might be linked to the fact that he teaches commercial law at university. If I'm wrong, he was the first to be granted a chair. So, otherwise, just a suggestion. I wonder if this idea of adding this adjective as if it were canon law or CQ law, which were taught at his university since the very beginning, might have sense since the text was presented as the first part of his textbook. And my question is linked to something that I am still searching, the fact that in Italy, every textbook of commercial law still starts with an historical introduction. And I questioned my colleagues of commercial law, and they said it's for grounded scientifically our legal knowledge, commercial methods. So it's just a quick question, and thank you very much.
Thank you for the question. Yes, so I think the title, the Universalgeschichte, I don't think it's wholly clear what Universal refers to. I think in the literature, the secondary literature, you find different things being asserted. You know, is it the method or is it his claim about merchant law? As we saw, he does use the word universal to describe commercial law. I think the importance is that it's not, he's saying that this doesn't belong to any national tradition. It doesn't belong wholly to a Roman tradition. It doesn't belong wholly to a Germanic tradition, as the two sort of great poles of 19th century sort of legal thinking. That it is something that exists sort of among and between jurisdictions. And I think he is basically sort of wrestling with what we're wrestling with, is that you say, oh, well, they all had different laws, although they did resemble each other quite a lot. And you sort of end up trying to move between these two poles, and he's trying to condense all this into a short historical introduction towards the end of his life and career, and, you know, trying to say the final word in a way that I think sort of scholars coming to the end of their career try to do, not always successfully. So So I think he, but the point is that he does try to qualify that remark, whereas usually people come to Goldschmidt and they read Universalgeschichte, they already know he started the Mercatorist tradition, and then they just leap in and it's like, oh, well, this is obviously what he was trying to say, whereas actually he's trying to say something more complex. And I do think that, you know, Goldschmidt is like, he was so influential that he creates the very environment in which commercial legal history, the terms of the debate, so much so that you can't even see them. You can't see them as contingent and historically created, you know, his influence is so vast. So I do think that tradition is still alive in textbooks, what he started.
And the last question is Anja Hahn.
Yeah, can you use the microphone? Okay, keep it next to your mouth. Thank you.
Thank you very much, Jake, for this journey through Goldschmidt's universe and the very detailed lecture, which is, as we could see, very important. I would only like to share an observation of mine while listening to your lecture. You highlighted the aspect of the autonomy, very difficult to spell, autonomy. And this autonomy and the quote you made, that it is always a question of politics that decides how the merchants can act or not. Yes, I think that is a very, very important question, and that makes, for me, a link to the question we had before, the establishing of jurisdiction, the influence that sovereigns had to establish a special jurisdiction or not. So this, what you meant with how political dimension, and I think that what you described and what we discussed belonging to your speech is at this point very close together. So we should respect this political dimension of our work in future, in research and future.
I must say, I do remember an event, I think 5 years ago, when Maria suggested that we might be entering a political turn in commercial legal history, and it wasn't much taken up by Pierre. But actually, I think that's somehow what we will end up doing. So,
Thank you very much. Thank you very much to both speakers and to the panel. And now we have a coffee break, and we will reconvene in 20 minutes.
Yeah, in 20 minutes, please.